A number of tenants have this mindset that once they are served with notice to quit or the 7 days notice, that they're no longer under an obligation to pay rent. Hello everyone, you again, welcome to Jaded Law channel. Again, this remains that law-based channel where your legal needs are met, where your issues are adequately addressed, and of course your questions are answered. Again, I remain your host, Mrs. Omongo Obe. Today I will be talking about some misconceptions as they relate to the recovery of possession. Like we all know, arrears of rent is one of the reasons why a landlord would want to recover possession from a tenant in the first place. So where tenants owe rents running into millions of naira or thousands of naira, rents owed for 1, 2, 3 years. Of course, the landlord, once he gets tired of all the excuses as to why the rents have not been paid, would want to seek to recover possession, and of course will take steps to serve the tenant with the notice to quit. Now, does the service of the notice to quit mean that the tenant should no longer pay the arrears of rent? The reason that I found it very important for us to talk about this is the fact that a number of tenants have this mindset that once they are served with notice to quit or the notice of owner's intention to apply to recover possession, that's a 7 days notice, that they're no longer under an obligation to pay rent. And they say things like, our landlord has served us with quit notice, we don't need to pay anymore. Seriously, I really don't know where they got that information from. There is no law that states that once a tenant who's in arrears of rent has been served statutory notices that he or she no longer has the responsibility or obligation to pay the rents, the arrears of the rents that is owed the landlord. The tenant has a responsibility to ensuring that he settles every arrears of rent up to the point where he vacates the premises. However, if the landlord accepts rent beyond the period of the quit notice, then a new tenancy automatically commences and that quit notice becomes ineffective. What do I mean by this? Let's take for instance that the quit notice stipulates that it will terminate the tenancy on the 29th day of February 2020. And so the tenant pays up to that 29th of February 2020 and then pays rents in advance beyond that date. If the landlord accepts that rent, then a new tenancy automatically commences. And what that means, or the implication of this, is that the quit notice that was served on a tenant becomes inoperative or ineffective. If, on the other hand, the landlord does not want the tenant to continue and the tenant, trying to be smart, pays into the landlord's account monies beyond the date that the quit notice ought to expire, then what the landlord should do would be to send the balance, that's the difference, back to the tenant if he does not want a new tenancy to commence. Another misconception is the fact that sometimes landlords feel that where a tenant vacates the premises owing so much rent that it becomes impossible or impracticable for them to recover the arrears of rent. This is a misconception. If a tenant vacates the premises, so long as the landlord is able to locate him wherever he is moved to, the landlord can proceed to court and also get judgment for arrears of rent, which said judgment can be executed. I believe that you have learned something today. Again, ignorance of the law is no excuse. I would like you and urge you to subscribe to this channel. Get your friends, family, loved ones, and even your enemies to subscribe as well. I'll see you next week. And next week we'll be talking about an entirely different topic. You don't want to miss it. See you next week. God bless you.